In this presentation, we're going to be looking at some basic underlying concepts, things like privacy, probable cause, and reasonableness, and these are found in Chapter 3 of your textbook. What type of pleas can you make if you're a defendant in a criminal case? Well, everybody well aware you can plead guilty. That's how our plea bargains work. That's how the vast majority of the pleas are, in our criminal justice system, over 90%, as a matter of fact. You can also plead not guilty. I didn't do it. I'm innocent. Though not guilty doesn't necessarily mean innocent, it just means that they weren't proved beyond a reasonable doubt that they are guilty of the offense. Next, you can plead no contest or nolo contendere. This was the plea that our Vice President Spiro Agnew used when he was thrown out of office in the 1970s on corruption charges. He didn't plead guilty, he pled no contest. And then finally, you can also plead that you're not guilty by reason of insanity. It's a defense to your prosecution. That's not saying you didn't commit the crime. It's that you are not criminally responsible for the crime because of your mental capacity, basically not knowing right from wrong. As I just mentioned in the previous slide, plea bargaining occurs in the vast majority of the cases, over 90%. It's an essential component of the criminal justice system. If we didn't have plea bargaining, our court system would be so backed up it would be unreal. Plea bargaining is the disposition of a criminal charge by an agreement between the prosecution and the accused, generally worked out between the attorney for the accused and the prosecutor's office. The plea negotiation, the defendant's criminal attorney will talk to the state's attorney, in Texas that's the district attorney, and try to negotiate a plea or deal that is best for their client. The defense attorney must inform his or her client of any reasonable offers made by the state attorney's office. The plea bargain may require a guilty plea, but in some cases they'll allow them to plead no contest, in which case the court will find them guilty. They also have to waive certain rights, as outlined above. You're going to waive your right to have a jury trial. You're going to waive a right to self-incrimination because you're saying you did it. So obviously you're waiving that right to not testify against yourself. If a plea bargain is made and agreed upon by both sides, the judge is not obligated to accept it. If he thinks that the plea deal is too lenient or too strong of a deal against the client, he can decide that he doesn't accept it. It is only a recommendation made to the judge. However, if the judge says nope, that's not severe enough, the judge can't then give him a more severe penalty than was pled upon. You're going to have a new plea bargain. If the judge rejects the plea, the defendant can withdraw his guilty plea. And you're saying about 98% of all criminal cases are resolved with some form of plea bargaining. So as you can see, that's just the vast majority of the time. It's so rare that a case goes to trial. And the more serious the case, the more likely it will go to a trial. Nolo contendere is just about pleading guilty, but you're not admitting guilt. A lot of times people will do this because of civil liability. When you plead guilty or a nolo contendere, you're going to waive your right to a trial by jury, the right to confront and cross-examine witnesses, the right to compel the attendance and testimony of witnesses. You can't subpoena somebody to court if you're not going to have a trial. The right to testify on your own behalf. The right to be free from being forced to incriminate oneself, because part of the plea bargain is you're going to usually admit to all the elements of the charge, and the right to be presumed innocent until proven guilty, and quite often the right to appeal one's conviction. However, there are many appeals that are based on I will plead guilty, but if the lower court judge rules that evidence was obtained legally, that statement was obtained illegally, you can plead guilty, but with the right to appeal it based on whatever evidence you're trying to get thrown out. Now, it's pretty much if the evidence you're talking about is the evidence, the drugs in the case, you're not going to get a conviction without them. If a higher court overturns it, throws it out as being illegally obtained, then you can, then pretty much withdraw your plea because obviously the state's not going to have a case against you. So in those limited cases, you would have a right to appeal. But for the most part, when someone pleads guilty, they're going to withdraw their right to appeal the conviction. If you're arrested and you're placed in jail, you are going to be held in a jail or a county jail or some other municipal facility until your trial. But you can get out on a bail bond, which is money put aside as a promise that you will appear in court, and the reason behind it, if you don't appear, then you lose the money. So you have a right to have bail for anything except a capital offense. The bail hearing, the judge may place certain conditions on your freedom, such as you can have no contact with the victim in the case, have no contact with children, depending on what the charge is, have no contact with the victim, could actually put you on a GPS, so that you stay within the area. They can take your passport so you can't travel outside the country, can tell you not to travel outside the state. There can be quite a few conditions. All individuals, again, except those charged with capital offenses, have a right to have bail. However, bail can be so excessive that you can't make it. So, in theory, you could have bail. You just can't always afford to get out on the bail when it's too high and you have no means to pay it. On the other hand, an individual who's already been convicted of an offense doesn't have a right to have bail. So if you're already on probation for an offense and you violate your probation and they issue a warrant for violation of probation or violation of parole, those can be no bond allowed, because at this point you've already been convicted of the offense. There's no proof of innocence or guilt. You've already been proven guilty. You've just violated some condition of your punishment. Bail is set by the court's discretion on a case-by-case basis, but generally speaking, it's going to be set based on certain criteria based on the seriousness of the offense and the previous history of the defendant. And again, it's not always really the judge that sets it. It can come down from a written list some places on misdemeanor cases where it's all automatically a $5,000 bail or $500 bail on a Class B misdemeanor with no previous convictions, or it can be set by a recommendation of the prosecutor. And generally speaking, the judge goes along with the recommendation, though they have a right to change whatever is recommended as the bail or the bond set. If the bail is too high, or in the defense attorney's opinion or the defendant's opinion, then the defense can request a bail reduction hearing. The defense needs to show that the defendant does not have enough collateral to pay such a high bond, that they're not a flight risk. If you're already out on bond for fleeing the jurisdiction, on a fail to appear bond, that's going to be hard to argue. That you have some type of ties to the community. If you're wanted for murder in Texas and you're from New York and you just happen to be down here in Texas when you killed somebody, your bail is probably going to be much higher because you don't have any ties to this community. You're going to go back to New York, and it's not going to be that easy for us to get you back in here for the trial. And then you're not a danger to the public or the alleged victim. If you've been stalking someone and you're being arrested for the 15th time for assaulting them or something of that nature, there's a good likelihood the bail is going to be increased to a level where you probably aren't going to be able to make it because you're a danger to the victim in the case. And there are instances in which a judge can deny bail, or bail can be denied but the defendant is entitled to a hearing within 48 hours of their arrest to determine whether to keep the bail denial. Pretty much the only time you're going to find a no bond allowed, though, is going to be on a capital offense or on violation of probation or parole. There are different types of bail bonds or bail. There's the cash bond, in which the defendant actually pays the money up front, that the entire amount. So if there's a $5,000 bail, you pay $5,000, give it to the sheriff, they hold it. If you show up in the court, you get your $5,000 back. A bail bond is when the defendant uses a bonding company or a bail bondsman to borrow the collateral. The bondsman will charge a fee, and you don't get that money back. So if you got a $5,000 bond, often they'll charge 10%, so they may charge you $500. If they do that, then you'll pay the bondsman the $500. He'll put up collateral against it. You'll get out. When you show up in court, they'll release the collateral against him, but you don't get your $500 back. Finally, there's a personal recognizance bond, and that's basically it's your promise to appear. When the court uses its discretion to release you, they'll cut you loose, and it's just your word that you'll be there. There's no monetary, no money there that's going to promise that you're going to appear. Another type of pre-trial hearing is going to be a suppression hearing. Kind of alluded to it when I talked about the plea bargains where you would actually plead guilty pending the outcome of an appeal based on a suppression of some evidence. Now, suppression hearings occur when the defendant wants to claim there was an improper search, seizure, or statement was made so that the evidence or statement cannot be used at trial. When the court grants a hearing on the motion to suppress, the court can rule based on the motion itself, upon opposing affidavits, or upon oral testimony. You'll often see these type hearings in narcotics cases where they're going to say that the drugs were illegally seized, you didn't have probable cause, the search warrant was faulty for whatever reason, and then they'll have the officers come in and testify about the probable cause they had. They'll actually look at the warrants, they'll introduce the affidavit, and the courts will rule. For the most part, they're going to rule in favor of the state, and say that the evidence was admitted legally. Again, if the defendant loses, sometimes they'll plead guilty, but with the provision that they will appeal the decision of the court in the suppression hearing. And if they win that appeal, then of course, with all the evidence thrown out, then they'll be able to withdraw their plea. One other type of pretrial, not necessarily a hearing, particularly now in Texas, pretrial motions would be for discovery. Discovery is the process by which information about a criminal case is exchanged between the prosecution and the defendant, generally from the prosecution to the defense, not the opposite way. The defendant can file a motion for discovery before the trial, and then the state has to give them certain information based on what the judges rule. Well, Texas used to not have an automatic discovery system. This has changed as of earlier this year, but the defendant had to specifically ask for things, and the judge, and they had to show cause why they wanted it. Some of the evidence that they'll look at, or documents, statements, written, recorded, the evidence itself. They can get their witnesses to come, their experts to come look at evidence, that type thing. The actual evidence itself, or photographs of the evidence. As I said before, Texas didn't have automatic discovery, but that has all changed. That all changed with the Michael Martin Act. Michael Martin was convicted of murdering his wife and spent 26 years in prison. The time of the investigation, his toddler son had said that the bad man that hurt mommy was not his daddy, and that statement was not released to the defense attorneys. As it turned out, later on, through DNA evidence, it was proved that a different individual who eventually confessed was the actual murderer. But again, he spent 26 years in prison before that was proved. Well, the prosecutor in the case was a Ken Anderson. He later became a judge in that county. He had this information. He did not release it. Eventually, he was convicted of contempt in court and sentenced to, I think, 3 or 4 days in jail. The defendant, Ken Martin, on the other hand, spent over 20 years in prison for a crime he did not commit. Well, the result of this case was a new law passed called the Ken Martin Act that has to do with discovery and gives the defense a whole lot more latitude in discovery. This law went into effect in this year, 2014. The Michael Morton Act made multiple and massive changes to Texas discovery laws. It codified the ruling in Brady versus Maryland that the exculpatory evidence was mandatory that exculpatory evidence be given to the defense. And it also stated that the state has a continued duty to provide discovery even after the case is closed, even after a conviction occurs. There's also an easier application. Previously, a defendant would have to petition the court and show good cause in order to get a limited amount of information, and a police report actually wouldn't have been given as one of the things that the court were ordered to be given over. Now a defendant only needs to make a timely request directly to the prosecutor. Don't have to go to the court. Just call the assistant D up and say, hey, give me everything you got. The defense no longer needs to apply to the court in order to order disclosure or attempt to prove good cause, a maneuver which would typically engender resistance from the prosecutor. There may be a little bit of touch and go with them as far as what information they would give. Now there's no question about it. The complete police file will be essentially for the prosecutor to comply with all of these new mandatory things. Everything that you have needs to go to the prosecutor. Working notes, the whole 9 yards, a lot more than we used to give. Videotapes that are available. We're having to pull videotapes from cars that just happen to drive by a crime scene if they've got their video running. Everything. You just can't leave it out, even though it doesn't have anything to do with the case. If it remotely connected to it, it has to be given up. It requires the production of offense reports, recorded statements, witness statements, police statements, work product of the prosecutor and their investigators that are not otherwise privileged. The bill imposes a production of exculpatory and mitigating evidence to the defense, which is not a new requirement, but it actually codifies it. What is new is required production of exculpatory or mitigating evidence even after a person is convicted. For example, we had a case recently where an individual was caught in the possession of some type of drug. I believe it was cocaine. He immediately pled guilty, was sentenced to a short term in prison. It wasn't his first offense, and probably not going to be his last. The drugs were sent off to the lab, but we did not get the lab results until after the defendant was sent to prison. Once we got the lab results back, the drugs that he thought were cocaine weren't. He had bought something that was bunk, wasn't good stuff. But even though he had already pled guilty, under this new law, we would be obligated to let his defense attorney know that the drugs were not drugs and it was exculpatory. This occurred about a year prior to the law. We gave it over to the prosecutor. I'm assuming they actually notified the person's defense attorney, and I don't know what happened to the case, to be honest with you. But under the new law, we would have a legal obligation to let him go, or to let the defense attorney know. The defendant's attorney or the agent of the defendant attorney could allow a defendant, witness, or prosecution to review information obtained through discoveries so they can use it to develop their case. Well, if this law and the Public Information Act are in conflict, the Morton Act wins. Public Information Act is also known as the Open Records Act. This was where allows police agencies to keep certain information confidential. But in the case of a defendant that's been arrested, it doesn't apply. The Morton Act wins, and all the information is public or discoverable to the defense. Information that's made privileged by other laws, such as the identity of informants or personal identifying information, may be removed from discovery to the defense, but the prosecutor must inform the defense that the item's omitted. So if you redact something from it, you have to let them know that you are redacting it. Now, any information that is protected by other statutes must be protected by defense counsel. There's certain information that's released to them that they can't release to the general public. They can't take confidential reports or confidential medical reports and give them out to the press. They can only use it for their actual defense. First thing we're going to look at in this section is the exclusionary rule. It requires that evidence obtained by the police using methods that violate the person's constitutional rights be excluded for use in the criminal prosecution of the individual. First developed in 1914 in a U.S. Supreme Court case, Weeks versus U.S. At the time, it only applied to the federal court system. Well, in 1961 in Mapp versus Ohio, the exclusionary rule was extended to all states. The whole purpose of this is to deter police officers from violating individuals' Fourth Amendment rights. It does not, in most states, apply to evidence illegally obtained by private citizens unless the private citizen was working as an agent of the police officer. So, police officer couldn't tell somebody to go, break into someone's apartment and obtain information. That would be they would be then working as an agent of the officer. The exclusionary rule's main purpose is to try to prevent police officers from violating people's constitutional rights. Now, some argue that there are better ways to do this, such as holding the officers criminally responsible themselves through civil suits, through interdepartmental disciplinary measures. But the courts have held that the exclusionary rule is kind of the punishment for not following the Constitution. But there are some exceptions to this. This exceptions of the inevitable discovery being one. Through the fruits of the poisonous tree, anything that you obtain that leads you to other evidence, the other evidence is also excluded. So if you obtain an illegal confession from an individual and he tells you where the dead body is, and then you find the dead body, and inside the dead body you find the bullet, and you then match the bullet up to the suspect, well, the statement's thrown out, the dead body's thrown out, and since the dead body's thrown out, the bullet that was found in the body's thrown out. Since the bullet's thrown out, the evidence that the gun we used that belonged to the defendant's thrown out, and you're just all messed up. But there is the possibility of the inevitable discovery exception. He confesses, you get the statement thrown out because you obtained it illegally, you forgot to read him his rights, whatever. That statement's out. But the body has been left on the side of a road that is traveled, and once the sun comes up in the morning, most likely some citizen's going to drive by and notice the body, and that's the inevitable discovery. Because somebody else would have likely found it had you not even obtained this illegal statement. But to get this evidence entered, the prosecution must show by preponderance of the evidence that the information ultimately or inevitably would have been discovered by a lawful means. The person driving by, that's a lawful means. So this is great. We can use the evidence, even though we obtained it originally outside the Constitution. Well, yeah, unless you're a police officer in Texas or Indiana, because those are the only two states that do not allow the inevitable discovery rule exception. The Texas law that covers inevitable discovery is found in the Code of Criminal Procedures. The state's exclusionary rule expressly forbids the admission of any evidence obtained in violation of any provision of the constitutional laws of the state of Texas or of the constitutional laws of the United States. In 1996, Texas High Court of Criminal Appeals explicitly rejected prosecutors' arguments to ignore the plain text of the code. The legislature adapted an exclusionary rule that barred evidence seized illegally by private citizens even. Most states, it would just cover police officers getting evidence illegally. In Texas, it can cover private citizens also. The good faith exception. This occurs when an officer acting in good faith reliance on a warrant based upon probable cause. So you have a warrant, it is faulty through no fault of the officer, maybe for a technical reason, may have been signed wrong, whatever. If the officer's acting in good faith thinking it's good, then the evidence would be good. Well, let's go back to Texas. Texas does allow the good faith, but it's extremely narrow good faith exception. It does not allow evidence seized without probable cause to be admitted simply because the police good faith reliance on the warrant. The good faith exception applies only to a warrant issued by a neutral magistrate based on actual probable cause, and it only applies to small technical requirements such as typographical errors or omissions in the warrant, not on a lack of probable cause. In order for an individual to assert the rights of the exclusionary rule, they must have standing to invoke the exclusionary rule. For instance, we illegally obtained the statement from that individual who left the body on the side of the road. Eventually we found the body, we found the bullets, we found everything else. And we can't use it against the individual we illegally obtained the statement from. However, his co-defendant in this case, he doesn't have standing to make this, this claim of the exclusionary rule, because it wasn't his rights that were violated. It's got to be the defendant's own constitutional rights that have been violated in order to use the exclusionary rule. Privacy rights are another thing. They become, particularly in the modern day, we're kind of in an era of change with the new, social media, the web, the video cameras everywhere. We just don't quite have the same expectation of privacy we did 20 or 30 years ago. But the old property rights approach to privacy. Under common law, the security of one's property was sacred right, and the protection of that right was the primary government purpose. We were going to protect you against invasion from other people. It was initially the basis for the interests protected by the Fourth Amendment. The Fourth Amendment issues centered around the intrusions of these constitutionally protected areas. Whenever an individual may harbor a reasonable expectation of privacy, he or she is entitled to be free from unreasonable government intrusion. So if you do something standing on the street corner, you're not going to have a whole lot of right to privacy. But if you're behind your own closed bedroom door, you've got a lot more expectation of privacy. And it's going to vary by where you are, if you're at work, in whether you work in a public place or you work out of your home. I mean, that's going to have a lot of determination. Determining whether a person has a reasonable expectation of privacy requires that a person exhibit an actual subjective expectation of privacy, and the expectation is one that society is prepared to recognize as objectively reasonable. And again, if you're standing in your living room window on the ground floor of a busy street with the windows wide open, and you're doing something illegal because the windows are open and anybody walking by can see it, society's not going to think that you've got that much right to privacy at that point, because you're kind of showing it out to the public. But if you close the curtains, then your privacy rights are going to increase quite a bit. Define probable cause for search and seizure. The case of Carroll versus the United States said that probable cause exists where the facts and circumstances within the arresting officer's knowledge and of which he has a reasonable trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that seizable property would be found in the particular place or on the particular person. So again, we have to figure out exactly what a man of reasonable caution is, and once we figure that out, then we can determine whether that person would believe that there's a likelihood that certain property or contraband or evidence will be in a particular place or on a particular person. The preferred method to search somebody or try to obtain evidence from somebody is through a warrant. The warrant procedure is preferred because it places the responsibility to determine the delicate question of the probable cause on a neutral party, being the judge, as opposed to the police officer who got an interest in the case. Obviously, they want to be the one to search the individual. So, you've got a disinterested party who's going to look at it from, a different perspective than the officer in the street. And they also have more legal training than the police officer. Obviously, judges generally speaking, are lawyers, not always. And generally, they also have years of experience before they become a judge. Doesn't have to be, but that's the norm. Normally, even when we elect judges, we're going to have somebody that's got experience to be a judge. Now, the fact is, in Texas, JPs are often not lawyers, but when you get to the higher level of courts, county courts and above, they do have to be an attorney. Methods of establishing probable cause. Let's say probable cause is evaluated by examining the collective information in the possession of the police at the time of the arrest or the search. So we need to know what information you know before you do the search, at the time of the search, not what you later find out. Your later information could prove that, the information you had was wrong, or you could later get more information that would add to your probable cause. Either way, so you're going to look at the information that was available at the time. And the information known to the officer through his senses, that could be hearing, seeing, smelling, touching, the flight or furtive conduct of the suspect, the individual. Usually you see it when you're trying to stop a car in traffic and they're desperately trying to hide something under the seat, and they're keep looking back at the car. You got that action. They're the tough and stuff something, so they're trying to hide it from you. Observations and evaluation of real evidence. Admissions of criminal conduct. When you step out of the car and the guy says, "Oh, you got me. Here's my drugs." Hey, that's pretty good probable cause. False or implausible questions, answers to routine questions. The fact that you stop somebody and you ask them a simple question and they lie to you, that can add to your probable cause. The presence at a crime scene or in a high crime area. It's easier to develop probable cause in the middle of the night than it is in the daytime because things are normally more out of place at the time. Association with known criminals. The experience you have as an officer. Because then this individual has been arrested. You've arrested him yourself on more than one occasion, and you've known about their past criminal conduct. These things all add up to develop your probable cause. One of the methods we use for obtaining probable cause is through the use of informants, and there are special rules that have to do with informant. Informant is a person from whom law enforcement officers obtain information on criminal activity. And informant information may satisfy probable cause requirements in some cases. The court established a two-pronged test for determining the probable cause when an informant and when information in the affidavit was either entirely or partially obtained from an informant. And these two cases were Aguilar versus Texas and Spinelli versus the United States. They date back to the 1960s. Okay, the first prong of the test relates to the informant's basis for the information. How did the informant know it? Is it personal knowledge? Is it secondhand information? In which case, it's not going to be very reliable. The affidavit must show how the informant knows his or her information by demonstrating: 1, the informant personally perceived the information given to the officer, or 2, the informant's information came from another source, but there is good reason to believe it. Without this, the officer can still satisfy the first prong by obtaining as much details as possible from the informant and stating it in the affidavit. So the more information you have, the better. With informants, when they go inside a house, you're going to want them to describe the interior of the house, to give the address, the vehicles in the driveway. Things that are verifiable. The color of the house, what side of the street is it on? Do they have lawn ornaments? Some precise details. The second prong relates to the truthfulness of the informant. The affidavit must describe the underlying circumstances from which the magistrate may determine that the informant was credible or that the informant's information was reliable. Ordinary citizens, victims, witnesses are usually presumed reliable. John Q. Citizen who has no interest at stake comes along. He's not doing it for money. He's not informing to better himself in a criminal case. They're perceived to be reliable. One of the things that we'll often do is you'll run a criminal record and say that the individual who you obtained information from has no criminal record. Well, quite often they do, so you can't always do that. They're have a good reputation in the community and so forth. When it's a criminal informant, the credibility must be established by a statement on underlying facts and circumstances. Normally, you'll have the individual give you information that in the past. They'll do things like they call them dirty buys, where they'll send their informant in to make buys. He'll bring back the drugs, and you'll do it on numerous occasions for searching the individual to show that they don't have drugs on them. And then when they come back, they'll give you the drugs, and you search them again to make sure they still don't. So you do that a few times. That shows that they're reliable, or you use them in previous cases. That shows they're reliable. Then you can use their information for probable cause. Corroboration is very important when it comes to use of informants, and like it's talking about, that's why you want them to describe things in minute detail. Describe the house, describe the vehicles, describe the suspects or people at the house. These are things that you can verify by driving by the house and seeing, yes, they do have a flamingo lawn ornament in their yard, and the address is 1234 with the 4 hanging off to the side. The gutters are falling off of the house, or they've got 3 cars in the driveway. Those are the things that you can verify. So you want to be able to do this because that kind of goes to prove the truthfulness of the individual. Corroboration means the strengthening and confirming the information supplied by the informant with supporting information obtained by law enforcement. As I said, you can do this by surveilling the place and seeing the number of individuals coming and going and spending a short period of time, which your informant has already told you they do. By describing the property, describing the individuals. A whole bunch of other methods, or using a second informant to buy at the same place. That will definitely corroborate the information. The Gates test. Under the Gates test, the totality of the circumstances for whether informant testimony can serve as a basis of probable cause. The task of the issuing magistrate is to make a practical, common sense decision whether, giving all of the circumstances set forth in the affidavit, there is a fair probability that contraband or evidence of crime will be found at the particular place. So the judge is going to look at everything. It's not, again, looking at the minutia, the particulars of the case. You want to look at the totality, and this is what we often use in probable cause. It's going to be the totality of the situation, the time of day, the area you're in, the suspicious furtive actions, the informants describing the person, and you corroborate at that. It's a totality of things. Of course, reasonableness is a very important part of the Fourth Amendment because it says that there will be no unreasonable searches and seizure. But what exactly is a reasonable search? You don't need probable cause to search somebody at an airport because they consider the safety of us above, the safety of people as a whole above the privacy of the individual. So they don't believe it's unreasonable for us to search somebody at an airport or any other point of entry into the country. And airports are considered points of entry because you can fly into them from outside the country. Same thing when you get on and off of a cruise ship or you cross the border into Mexico. You don't have a right to privacy in these situations, not because they've got probable cause to search you, but because it would not be considered an unreasonable search or seizure. Determining reasonableness of any search involves a twofold inquiry. One must consider whether the action was justified at its inception, and then one must determine whether the search as actually conducted was reasonably related to the scope of circumstances which justified the interference in the first place. So, maybe strip searching someone in the airport in front of everybody would not be considered reasonable, or under circumstances, using a wand to search somebody for a weapon would be considered reasonable. So you got to look again at everything. Well, next week we're going to be looking at Chapter 4 on criminal investigatory search warrants. Should be real exciting. So y'all get prepared for it, and remember to finish up your discussions.